Hello students, welcome to AKS. We have discussed about fundamental rights and the directive principles of state policy. Now let us try to discuss about fundamental duties which are mentioned in Part 4A of the Constitution. Part 4A of the Constitution. So these have been added by the 42nd Constitutional Amendment Act of 1976. So that's why a new part was added to the Constitution in the form of Part 4A, and a new article in the form of Article 51A was added to provide for the fundamental duties. So originally, it had 10 fundamental duties. By the 86th Amendment Act of 2002, the 11th fundamental duty was added. So India borrowed the essence of fundamental duties from the Soviet Union. Okay. So these provisions related to fundamental duties were added by India by getting inspired from the USSR or the Soviet Union. The directive principles of state policy were inspired from the Irish Constitution. Okay. India incorporated the fundamental duties in the Constitution based on the recommendations by the Swaran Singh Committee. Swaran Singh Committee recommendations. Now let us look into the nature of fundamental duties. What is the nature of fundamental duties? Fundamental duties are non-enforceable. By now you know what do you mean by non-enforceability. Like the directive principles of state policy, they are not enforceable. That is, the courts in India cannot issue directives to the state to perform fundamental duties, or cannot issue directives to the citizens to perform fundamental duties. Number two, duties and rights represent two sides of the same coin. Thus, fundamental duties is the performance of duties that entitles a citizen to claim rights. Okay? It is through the performance of the duty of your fundamental duties as a citizen, you can claim your fundamental rights. That is one of the essence of fundamental duties, why they were included. Number three, fundamental duties reflect the values and traditions of India's civilization. Values and traditions of India's civilization. For example, King Ashoka made a state policy to protect and conserve environment, which was followed by King Akbar. For example, during the times of Akbar and Ashoka, women were held in high esteem. So these are some of the fundamental duties which were part of India's cultural values and traditions, which were included in the Constitution by the 42nd Amendment Act. So now you must be asking me, sir, what is the legal status of fundamental duties? Legal status of fundamental duties. The Parliament and state legislatures can enact laws to implement the fundamental duties. Such laws to implement the fundamental duties can always be declared as reasonable restrictions on the fundamental rights. So the Parliament and state legislatures can enact laws to implement the fundamental duties, and they can be declared as reasonable restrictions on the fundamental rights. If it is brought to the notice of the court that the citizen has a record of violation and non-performance of fundamental duties, then the courts may not issue a writ to enforce fundamental rights of the person as a reasonable restrictions on his exercise of the right of fundamental rights. So to enjoy your fundamental rights, you should also perform your fundamental duties. So we have seen that the 11th fundamental duty was added by the 86th Constitutional Amendment Act. 86th Constitutional Amendment Act 2002 provided for the 11th fundamental duty. What is this 11th fundamental duty? A parent should ensure that their child or ward is getting at least primary education between the age of 6 to 14 years. By the 86th Constitutional Amendment Act, as you know, this was added. And also this was based on the recommendations of Justice Verma committee, who said that early childhood care should be ensured by the parents. So now let us discuss about the conflict between fundamental rights and directive principles of state policy. What are the various fundamental duties we will look at later. Okay. But we will look into what is the conflict between fundamental rights. What is the conflict between fundamental rights versus directive principles of state policy? See, most of the fundamental rights represent individual freedoms and they are justiciable. And the difference between them is the directive principles, these are collective privileges. These are collective rights and are representative of a just and egalitarian society, and they are non-justiciable. So this led to a legal conflict. So there was a balance that was sought to be adopted so that there's a compromise of the fundamental rights for the collective rights of a just and egalitarian society. So this led to, so whenever the state sought to balance individual rights with the collective rights of the society, this led to a legal conflict. Okay, so by various laws, various acts of the Supreme Court, so various so the Supreme Court, in its various judgments, tried to resolve this legal conflict between the fundamental rights and the directive principles of state policy, which we have seen in various cases like the Golaknath versus the state of Punjab, okay, the Minerva Mills case, the Kesavananda Bharati case, okay, and finally the Minerva Mills case, which provided for the doctrine of harmonious construction between the directive principles and state policy, which means that in reality, the doctrine of harmonious construction. By this, it means that there is no conflict per se between the fundamental rights and directive principles, but there is only a difference in the constitutional status of the fundamental rights and directive principles, wherein, as we know, fundamental rights are justiciable, but directive principles are non-justiciable. Harmonious construction is a judicial formula to be used by judges when it is resolving a dispute between fundamental rights and directive principles. The court should examine if the particular law implementing any directive principle is enabling more people to enjoy their fundamental rights more meaningfully. Such a law is constitutionally valid even though it violates an individual's fundamental rights. So thus, it gives precedence to directive principles over fundamental rights regarding Article 39B and 39C. Harmonious construction will allow the parliament and state legislatures to allow other directive principles other than Article 39B and 39C also, if those directive principles enable collective rights for more people on a case-by-case basis. So this is the present position of the conflict between the fundamental rights and directive principles. And also the laws implementing directive principles in Article 39B and 39C will be valid even if they violate Article 14 and Article 19, which we already saw. But such laws are also open for judicial review. And Parliament's amendment power as a constituent assembly will retain as long as it does not violate the basic structure of the Constitution. The Constitutional Amendment Acts which amend the Constitution, which amend our fundamental rights, will be subject to judicial review. This is what the court had said in the Minerva Mills case of 1980. Okay. So in our next video, we will deal with the